Hello, readers and viewers of the IACL blog. My name is Mariana Velasco-Rivera. I am the associate editor of the blog. Today, I have the pleasure to welcome Ross Dixon and David Landau to discuss the recently published book, Abusive Constitutional Borrowing, Legal Globalization and the Subversion of Liberal Democracy, published by Oxford University Press. Ross Dixon is a professor of law at the Faculty of Law and Justice at UNSW Sydney. Her work focuses on comparative constitutional law and constitutional design, constitutional democracy, theories of constitutional dialogue and amendment, socio-economic rights, and constitutional law and gender. Her work has been published in a range of books and leading journals in the US, Canada, the UK, and Australia. She was formerly an assistant professor at the University of Chicago Law School and has been a visiting professor at the University of Chicago, Columbia Law School, Harvard Law School, and the National University of Singapore. She is a Manos Research Fellow, director of the Gilbert and Tobin Center of Public Law, deputy director of the Herbert Smith Freehills Initiative on Law and Economics, co-director of the UNSW New Economic Equality Initiative at UNSW, and formerly co-president of the International Society of Public Law. David Landau is the Mason Ladd Professor and Associate Dean of International Programs at Florida State University College of Law. He is a scholar of constitutional theory, constitutional design, and comparative constitutional law. His recent work has focused on a range of issues with contemporary salience, both in the US and elsewhere around the world, including constitutional change and constitution making, judicial role and the enforcement of rights, impeachment, and the erosion of democracy. He has published in many journals, including the University of Chicago Law Review, the Harvard Journal of International Law. Professor Landau's work has been cited by high courts of several countries, including the Supreme Court of Israel, the Supreme Court of Canada, the Constitutional Tribunal of Chile, and the Supreme Federal Tribunal of Brazil. Since 2012, he has been the co-founding editor of iConnect, the blog of International Journal of Constitutional Law. He holds an AB, a JD, and a PhD from Harvard University. Thank you so much to both for being here. So we can jump straight to discuss your work. And I would like to start with you, Ross, starting with, the title is very, very provocative because it alludes to the literature on democratic backsliding in general and to your work on abusive constitutionalism and abusive judicial review, both, individually and collectively. Could you tell us a little bit about the book, exactly what abusive constitutional borrowing and how it relates to and distinguishes from the phenomena that you have identified in your previous work?
Well, thank you so much, Mariana, for the opportunity, and to you and the IACL for giving us the opportunity to talk about the book. Many people will say it's the wrong title because borrowing is used in a very metaphoric sense to mean either the use of foreign or international law as inspiration for what we see as abusive practices or as justification. So we use the word abusive borrowing broadly, and I'm going to explain what we mean by abusive. But basically, we started with David's 2013 article on abusive constitutionalism and did a bunch of work extending and building on that idea to think about the role of doctrines like the unconstitutional amendment doctrine in preventing abusive change. We thought about how tiering in design might be able to help, and a range of other design solutions. And that's the subject of ongoing work. But one of the things we noticed in abusive judicial review and some of the other work we were doing, including my own work on rights as bribes, is that liberal democratic constitutionalism isn't just a constraint on abusive constitutional change. In some ways, it's now becoming a handmaiden or tool for the erosion of democracy. And so the book really tries to notice what is a very broad trend, which many people have written about and noticed, which is a trend of abusive constitutionalism or backsliding in even quite consolidated democracies. And it argues that international law, and especially comparative constitutional law, isn't just a roadblock or deterrent or sort of constraint on that process. It can sometimes be the facilitator or handmaiden of that process. And so we're actually intervening in what is a large terrain in a quite narrow part of the debate and saying this is a cautionary tale to the enthusiasts and proponents of our global public law moment, people like all of us in the IACL and ICONS, to say that our discourses and practices are being abused by would-be authoritarians in ways we should be much more mindful of and being willing to call out in relevant cases. So let me just say a little more about the word abuse and then turn it back to you, Mariana. So the word abuse in this context really means a use that is anti-democratic. And we have developed an idea of democracy in this context, which we call the democratic minimum core. And it's not an extremely thin or procedural conception of democracy, because it suggests that democracy consists in free and fair multi-party elections, but also political rights and freedoms and a minimum set of checks and balances or institutions capable of enforcing commitments 1 and 2. But we say abuse occurs in the weak sense whenever the democratic minimum core is eroded or adversely impacted. And we say that there's also circumstances where abuse is stronger, where people actually knowingly or intentionally erode the democratic minimum core. And so we define abusive borrowing in the end as the use of international comparative precedents so as to erode the democratic minimum core, either in effect, that's the weak sense of the term, or knowingly or intentionally, that's the strong sense of the term. And that's the phenomenon we're trying to notice and call out. And we provide a pretty broad range of examples of how this is occurring as the basis for a book that says this is a really serious part of the age of democratic backsliding and we need to pay more attention to it.
Thank you so much, Ros. So David, now that Ros has kindly explained to us what abusive constitutional borrowing is, could you tell us how how abusive constitutional borrowing succeeds, and what can we do as scholars and or as global citizens to stop it?
Thanks so much, Mariana. I mean, so a lot of what we do in this book is trace the phenomenon, right? As Roz has laid it out. I mean, one thing I think we show is how prevalent it is, right? We draw on examples from a huge range of countries, some of which are quite, somewhat well known in the literature, places like Hungary, Poland, Venezuela, but a number of which are not, we think, places like Cambodia, Rwanda, Fiji. So we try to draw on a pretty broad mix of examples throughout the book, and look at the abuse of a number of different things closely associated with liberal democracy, rights, for example, the abuse of both kind of gender quotas and hate speech laws in Rwanda, environmental law in Ecuador, courts, the use of courts to ban the opposition in places like Cambodia and Thailand, the use of constituent power and abuse of it in Venezuela to hold kind of sham-like constituent assemblies, the unconstitutional constitutional amendment doctrine to secure presidential re-election throughout Latin America based on a kind of fictitious human right to re-election, the use of constitutional identity doctrine in Europe and places like Poland and Hungary, or its abuse, and the abuse of political constitutionalism or kind of dialogical constitutionalism in places like Hungary, Poland, and Israel. And so we try to cover a lot of ground about, what it is. And then, of course, as you say, the questions then become like, well, why does this work, right? And what do you do about it? And the why it works, I think is complex, but I think what Roz and I show through these case studies is you have different audiences for this kind of thing, kind of both international and domestic audiences. The weight differs by issue, by context. So sometimes you may mainly be aimed at the domestic population, civil society, other times at international NGOs, international institutions. Part of what you might be trying to do is convince populations that you're actually doing something liberal democratic when you're actually carrying out an anti-democratic act. But even if it doesn't do that, it still, we think, has the effect of making responses kind of a lot harder to formulate, right? or even to play in the interests of groups. An example, like a gender quotas in Rwanda, Kagame is kind of feted or celebrated by the international community, international organizations for a commitment to gender equality. Similar story with environmental rights in Ecuador. And often, I think, as we show, these end up being bad trades, right? Where there's elements of both kind of confusion and also kind of willfully kind of ignoring the broader issue of like what's happening to democracy, because in part these groups are oriented towards certain goals. Now, the what to do about it piece, I think that's the hardest. I mean, we spend the last chapter on that about responses after going through all of this theory and all of these examples. But it's very hard. I mean, I think a lot of what we want to say is just recognition that those of us in comparative constitutional law and adjacent fields like international law should be more aware of this phenomenon and kind of more attuned to basically this dark side of legal globalization. And that's valuable, right? But beyond that, we do have a set of suggestions. Some of them are about here we're really talking about conceptual responses. We've got a project on design that is a separate project on kind of the resilience of constitutions. And conceptually, I mean, we think, kind of transnational, international monitoring could be improved. We build on scholars like Kim Shepley to suggest ways in which international monitoring could be made more holistic, also more legal realist, right, and kind of less formalist in nature. We also have a set of responses about norm construction, thinking about how we, as scholars, our own responsibility, right, and also policymakers for designing norms that are more abuse-proof in essence, right, that we should ask the question and kind of consider the prevalence of abuse. In the extreme, you might say that a liberal democratic norm shouldn't exist at all because the risk of abuse is so high. But even absent that, I think there's ways in which you can more carefully design norms, not to eliminate abuse, never going to happen, but being more attuned to the risk, with very powerful doctrines like the unconstitutional constitutional amendment doctrine or constitutional identity, memory laws. It is useful, right? I think it reduces the prospect of abuse. Finally, at the end, we raise in kind of a more speculative fashion, but the nature of liberal democratic constitutionalism itself, right? And the need for a kind of more genuine dialogue. This stuff that we're describing thrives off of a kind of mimicry. And what one would want is a more deeper, thicker dialogue, real experimentation perhaps, about some of the content of liberal democracy. Our red line, as Roz referred to, is preservation of the democratic minimum core, right? That's the key that needs to be preserved and called out when it's abused. But within those confines, I think a more genuine experimentation would be a lot better, a lot healthier than the kind of mimicry that currently goes on and the kind of abuse of it that we're calling out in this book.
Thank you, David. So Rose, given the wide range of problems and issues that you seem to address in the book, what do you hope to see as the book's main contribution or contributions?
Well, thanks, Mariana. I think, there's a number, and the person reading it will decide partly based on why they're reading it. And, we're sort of speaking to a variety of scholars and contexts. But I think it is really threefold. The first is to identify the phenomenon and call it out. The second is to note its breadth, both as to geography and the kinds of norms that are being abused, right? So it extends to rights and to notions like the unconstitutional amendment doctrine, but it also extends to genocide, memorialization laws, to speaker's corner, to notions of the rule of law, to a whole range of its suite of institutions. So geographically broad and very broad in terms of the kinds of norms. And thirdly, we note that it can take a variety of forms, so that the breadth point is amplified by the fact that we think abusive borrowing can take at least 4 overlapping forms. So firstly, it can involve radically superficial borrowing. Secondly, it can involve highly selective forms of borrowing. Thirdly, it can involve radically acontextual borrowing, or fourth, anti-purposive forms of borrowing. So all borrowing, I mean, borrowing doesn't exist in comparative law. As Kim Lane Shepley said to us, you don't give stuff back, but it's the use of foreign ideas in your own context. All forms of borrowing of that kind involve a degree of change or adaptation. So you don't take the whole thing, you take parts of the rest of the world's experiences. But this is both different in purpose and different in degree, right? So it's radically more selective or superficial. And all of these forms involve a decoupling of form and substance, where the ultimate aim is to take the form and not the substance in order to erode democracy. But we think it's actually really useful to think about the 4 different ways in which this occurs in order to appreciate the breadth of the phenomenon. So calling it out, noticing its geographic and subject matter breadth, but also third, noticing its breadth in terms of the techniques that it can involve.
Thank you so much, Ros. Yeah, this is very, very interesting. So David, just perhaps a little bit, related. Yeah, you already mentioned Kim Lane Shepley, but I would like to ask you more specifically whose work was influential on you, both of you, throughout the course of the project.
Yeah, thanks for that. That's a great question. I mean, it's a hard one because it's like an Oscar speech or something, right? You've got to mention there's so many debts that we've accumulated in the course of writing this. Hopefully the music won't come on while I'm in the middle of like mentioning people. But I think, we're really fortunate, I think, as scholars to now have such a rich literature on these questions, and also to be a community that we talk, I mean, it's of the kind of size and nature where we all know and kind of rely on each other's work. And as Roz said, we're sort of like, what we were trying to do in this book was carve out this piece, a discrete piece, but a really important piece of this broader phenomenon or literature, basically, on democratic backsliding. So we draw on a lot of recent comparative constitutional law on the topic. Obviously, Tom Ginsburg and Aziz Huq's book, Sam Issacharoff's work on democratic backsliding, the role of courts. Of course, the political science literature on these questions, the recent book by Levitsky and Ziblatt, right, has been important. So we've got all these kind of important rich literature in comparative constitutional law, in political science. And then, as I mentioned before, but Kim Shepley's work on autocratic legalism and ideas related to it was really important to us. We draw on her work, in developing our own ideas about not only the phenomenon, but responses. And then there are a number of kind of younger scholars or area experts that we're indebted to. Some of them are really experts on particular contexts that we drew on heavily. It was hard to write a book, with so many different examples. We're naturally dependent in some ways on local literatures, and we tried to be, careful in using those literatures. So an example is Raul Sanchez-Arevari's excellent work on Venezuela and on the role of the courts in Venezuela in a competitive authoritarian context. Also, Alvin Chung, excellent dissertation and work on abusive legalism, which was really an important work for us, and one that we were in some dialogue with it. It was kind of neat because he was in dialogue with some of our earlier work, and then we kind of were in dialogue with his dissertation. So that's some of them, right? There are many others. I mean, Ron Herschel, from a kind of personal perspective, was instrumental in motivating us to write this book, and it's really a conversation with him that led us to kind of sit down and really start work in earnest on it. I'm sure I'm missing some. Roz, am I leaving somebody out?
Well, one has to, right? Otherwise the music goes on. But let me just add 2 things. One is, I'm sure that people like Wojciech Sidursky and Adam Czarnoda and Gabor Halmai and Bojan Bugaret would be delighted to be called young scholars. But, I think the point that David makes about method is that we do try very heavily to go into the material as a matter of primary research for all the countries that we talk about, but some countries we can't. So for Thailand, we relied heavily on the work of people like Kem Thong and Sarah Bishop and Bjorn Dressel because we can't read Thai. And, you know, for other countries like Rwanda or Kenya or South Africa, we can, you know, we can read, but we still wanted to make sure we were engaging with local experts. And so for Eastern Europe, for Latin America, you know, for all of the countries we talk about, we engage in primary research, but where there's a linguistic barrier, obviously David speaks great Spanish, but where there's a linguistic barrier, we rely heavily on other colleagues. Mark Tushnet has raised a concern with us about our method in that context and whether we're just listening to kind of liberal progressives and not taking seriously the kind of defense of abusive constitutional regimes and changes. And we're very careful to try within all of the countries we talk about to cite and credit, if you like, people who might be respectable defenders of the regime. So not the real kind of full-blown unthinking kind of defenders, but the thoughtful defenders who say, well, look, this is actually within the zone of reasonable disagreement, or this is something that is legitimate. So someone like Adam Czarnota, who is, you know, very versed in Poland and who says it is legitimate, is someone we think about and refer to, and we try and do that, you know, in a bunch of cases. So that matters. And then the last thing I would say is, I don't think either of us were directly influenced by this, but we noticed the parallels in the course of writing to some of the critical legal studies writing and people like David Kennedy, who write a book called The Dark Sides of Virtue about human rights law. Now, David is making a classically argument in The Dark Sides of Virtue where he says, human rights, if you like, are not a very effective source of constraint. They make us feel better about ourselves as those who are exercising power. So actually they just legitimate injustice and make us feel better about all the bad things we do in the world. And so they really help us do great injustice and give us blood on our hands. We're not critical legal studies scholars, and we don't think that we should kind of give up on international or comparative law and do politics all the way down. We think that there is still the capacity for law to constrain, but we do think that we've been too uncritical about comparative constitutional law as a field that is pro-democratic and constraining rather than ambivalent in potential. And so part of you know, this project is a kind of melding of the optimism of a book like the Ginsburg-Hook or Issacharoff book about the way in which law and institutions can constrain with a kind of Kennedy-esque pessimism. So it's kind of part critical studies, legal studies, part constitutional design optimism melded together to tell a story of optimism, but with real caution and realism about the dark sides of our shared field and project.
Thank you so much to both. Ros, I think you also already sort of like kind of suggested a reply or an answer to my next question, which is what inspired you to take up this project and how did you decide to undertake it as a co-author project?
I think that you know, why take up the project is really quite straightforward, which is this is a really serious moment for democracy. And, you know, I think all of us who work in the field want to say something if we have something useful or relevant to say in defense of things that we really cherish. And, you know, I've given talks about the book where a couple of folks have said to me, you know, do you really still think democracy is the best game in town? And I think, David, and my answer is definitely yes. Liberal democracy is something we're very committed to. It's imperfect, it needs updating. We talk about that at the end of the book. But we're very committed to it as a program of self-government and freedom. And we are not interested in kind of chucking it out because of its flaws or because it's endangered. So part of the political or philosophical motivation for the book is liberal democracy is under threat. We care about it. What can we do as scholars to call that out and contribute to reducing the risk? In terms of co-authorship, well, one could have a kind of substantive answer to that as well as a kind of practical one. The substantive one is, you know, this is a book that comes out of David's research in 2013 on abusive constitutionalism, but also draws on a bunch of my own work. and then joint authored work. And so it's a kind of a natural culmination of two complementary agendas. And secondly, there's a degree to which when you try and do a book of this breadth, it's easier and more reliable when you do it with people with different area expertise. So, you know, David is an expert on Latin America and particularly on Colombia and Venezuela that we draw on heavily in the book. I'm not an expert on anything, but I definitely know more about the former common law, British colonial kind of countries where Rwanda and Kenya and Fiji and other countries in that country, you know, category feature. So you can do more as a comparativist if you combine forces and do it in a way that draws on complementary country or area knowledge. And then I guess there's the practical, which is, you know, it's quite fun writing with other people. You know, you get the opportunity to test ideas. Two, you know, heads are better than one often. It's more interactive, and you know, we have complementary skills and attributes which make it easier to write a book together than to write it separately. And you know, I think that that is definitely a big part of it. But I'd say the final thing is actually something that I think is important about the attribution of ideas and credit, which is there's a degree in science where when progress is made between labs, you know, people get to kind of cross credit. Well, you got the protein and I figured out how to inject the protein and everyone gets the credit. There's a tendency in law to be like downplaying other people's ideas in order to get the credit because there's nothing as hard or fast as protein discovery. And so there's a tendency to kind of race to the answer against your colleagues. And you know, David and I found ourselves at a particular moment writing about the unconstitutional amendment doctrine, thinking about it in very similar ways. And we definitely had a conversation where like, well, we could race each other to get this idea out there and then, you know, figure out who to, you know, cite first or whatever, or we could try and combine forces. And so part of it was actually just about joint discovery at the same time of some of the very small components of the book, and a willingness to try what it would look like to collaborate in the interest of saying, let's not kind of race or compete for the idea here. Let's try and join forces and make the idea better.
Thank you, Ros. What about you, David?
Yeah, I mean, that's just covered so much good ground there, I think. I mean, for me, a piece of the motivation, I guess, for the project is just, I do see, you know, I think we both see, again, we're not crits, right? But we do see sometimes a kind of overconfidence or glibness to the globalization or discussion about comparative constitutional law, right? In a sense that a kind of, there is a, you know, a risk we think associated with that. And so part of, I think why we wrote the book is a kind of warning, basically. Be more careful with some of these ideas and doctrines. Look what they can do, right? Look what they're capable of doing if they're abused. And so that was a piece of the kind of practicals. Like, I think in a lot of ways, this is written in that vein, right, to the field and to scholars and kind of practitioners in the field. Beyond that, I would say, you know, how did we decide to undertake it as kind of co-author? I mean, like I said, the particular motivator was, you know, we had both in Sydney a few years ago, and we had a conversation with Ron Herschel in a coffee shop where he's like, you need to do this as a book, you know? And I think up to that point, we'd done a ton of articles together, worked well together. But I think at that point we thought, that makes sense, right? It makes sense to do this as a book length project. And we're really happy we did that. You know, I think it was a good decision, allowed us to pursue these ideas in kind of more depth. And beyond that, I would just say, you know, the writing the book seemed very natural because it really did build on all this joint work that Roz and I have done together, continuous conversations we had that we always have, right? Sort of consistently over time. And, you know, I think the other thing is co-authoring is great. Be careful who your co-author is, right? I'm very lucky to have a co-author like Roz, who's so terrific to work with. And someone where I think the relationship, you know, works so well and kind of so naturally together, where we complement each other's strengths and generally communicate and work well together. So this was really fun working on the book in in that vein.
Thank you, David. And Ross, what were the main challenges that you faced in writing this book?
So I think I would note three. The first is, how do you bite off a manageable piece of what is a massive field and problem, right? It's like the problem we're all worried about. And when you're thinking about something that big, you've either got to take a kind of panopticon view that by definition has to be fairly high level and can't get into the nitty gritty of a huge amount, or you have to zoom right in. And so one of the things we kind of struggled with for a time was, what's the right scope for the project? And, you know, I think that for more junior scholars listening, you know, books are different from articles. With articles, the best way to do that is just write it and then talk to your friends and colleagues and then figure out how to kind of chunk it up or add stuff or take stuff out. With a book, you shouldn't do that because you've spent a year of your life and then someone says, actually, you should excise half of it, right? It's not the best way of working. So we did spend quite a few months talking through what the right scope was. And, you know, we are going to write a second book if we, you know, can, you know, pull that off. And that's part of the kind of vision of this is the right scope for the project. And I want to sort of emphasize again what I said at the beginning. We think the phenomenon is very broad, but we think it's actually only like 10% or 20% of the problem, right? If the problem is bad electoral system design, economic policies that don't meet citizens' needs, a rising nationalism that doesn't think about immigration in a new and innovative way, you know, the degree to which the media has become less pluralized and people don't look across different platforms and understand the news in the way they used to. All these things are first order things. And the way in which Orban incites Germany or the US to justify his bad practices is like down the list, right? But it's down the list in a way that pertains exactly to what we do. We don't control media markets. We don't figure out exactly immigration policy. We do this stuff. And so we think it's really important for our community, but we don't necessarily think it's like the first order thing in the field, but you shouldn't always think about the things that are first order. You should think about the things that you have something unique and, you know, expertise based to say about. So the first thing was about scope. The second was to figure out how many countries to include and how that intersected with our expertise. One of our hopes is that this book will be something that people pick up in different contexts and extend. And so they'll say, you know what, this book doesn't talk much about Brazil, but Bolsonaro is clearly a guy who's doing this, and we're going to write something that extends and adapts our framework for Brazil or the rule of law. We're going to do it in a way that looks at, you know, what's happening in a whole range of areas. And that again was a sort of scope discussion and an expertise discussion. You know, we got pushed recently by Oren Tamir on our characterization of Israel. We call it in the book one of our more tentative examples or proto-abusive instances. But, you know, we're reasonably confident that what we say can be defended as reliable. And we had to grapple with that on what can and can't we include, where we're pretty confident that if smart people who know more than us about the jurisdiction come and read the book and debate it with us, that we'll still be comfortable with what we say. So there was a second question about expertise and scope. And I think one of the things is people have said to us, it's a very broad book. They really like the fact that it has lots of countries and they're not the usual suspects. They're global north, global south, and they're just unusual, right? I mean, the tendency with the global south critique is to say, look, we've looked at India and Colombia, so we're done. And we go beyond that, right? But we also had to think about not overstretching our expertise and capacity in a way that meant that we could still defend it when smart, tough-minded people came back and read it and said, but hang on, what about this case or this example? And, you know, I think David and I both in different contexts got really deep into debates in specific countries. Like I learned a lot about Thailand and the different views about what happened there. And we try and be really, really careful in how we write it up. But that was a factor. And I think the third one is really just about the kind of pace of life and how one thinks and writes. And I think that, for both of us, we write at different paces. We tend to kind of have different schedules or calendars because of the North American calendar and the Australian calendar. And it's easier with a short article to figure out how to do that, and trying to work out a bigger project, how it works across, different temperaments, different, calendars, and how to make the book kind of work. That was harder for sure. And, I'm an obsessive planner and David's not. And that, occasionally he would like not answer my phone calls because he thought I would be calling him to hassle him about the book. And, you definitely have to figure out with your co-authors how you want to work. And books are harder than short articles because there's more of the differences in working style. But I think a bit like friendship, co-authorship has to be based on shared strengths, but also complementary attributes. And, I've written with a lot of people. I like writing with people. I'm an extrovert. And I think that, my advice to people is it's a really rewarding part of what we do. You don't always get the same credit. So you have to be really careful with your promotion and tenure that you write enough by yourself to get the recognition and promotion that you deserve. But especially once you've got tenure, you can, make these choices. I've been criticized in Australia for writing a lot of co-authored work, whereas at Chicago, it was really valued. So you need to know the context you're working in. But I think for me, I really enjoy it. But I think you've got to acknowledge why it works and what is useful about the partnership, and then also realize people have different strengths and weaknesses and also different working styles. And I think books bring that out. And David definitely, would say that it's harder to write a book with someone who's an obsessive planner than it is to write an article. But I think we've worked that out, and that's part of the journey of learning to write a big project with someone and our working styles are really different, but that's actually part of the complementarities rather than, the differences. It's like friendship. You don't want people who are only interested in doing the same thing. We want to push each other to Mariana's going to take me one place, I'm going to take her another, and we'll both be richer for it.
Thank you, Ros. And what about you, David?
Yeah, no, I mean, there's a lot of ground that was terrific, and I agree with all of it. I mean, I think, I would say a couple of things. One is, I definitely encourage people to write books. I think the practice here differs. For example, U.S. legal scholars weirdly don't write a lot of books. People in the rest of the world do. It was done a lot of edited volumes and things like that. This is the first, I think the word is monograph, right? That done, and it was different. I think it requires a kind of patience in the sense it's kind of like whack-a-mole. There's always other stuff to do, right, with respect to the project. You do a piece of it, you get a chapter kind of in a position you want, and then there's all this other stuff. So it requires a lot of patience, time, kind of attention to detail. I think though, and again, that's where I think the who you're co-authoring with, right, and having a good relationship with your co-author matters immensely, right, for that kind of stuff. But I will say at the end of the day, it's so rewarding because it gives you a chance to explore ideas in a deeper way, right, in a way you really just can't do with an article. And I think ultimately that's really something really satisfying about that. And so I think that's a piece of it. I really would think you've got a big idea, a good idea. I think encourage, make it a book, the methodologically, Roz already talked a lot, I think, about this, is the challenge of using a number of cases. I just would encourage people, I think, not to shy away from writing a kind of a bigger piece and branching out to some cases. I think a lot depends on your research design and what you're trying to do, but I think it is very possible to do kind of very careful case study oriented work. Even if you're covering jurisdictions you may be a little bit less familiar with, and I think the field does need kind of a mix of stuff, but some very careful, narrow case study work, but also this kind of broader work, I think, has real value. And like I said, we do intend the book to some degree. Roz mentioned this as a kind of invitation. Despite the breadth, there's all these important cases we made choices not to cover, but we think are really important. Big parts of the post-Soviet world, for example, places like Brazil and India, to name two kind of big ones. And I think, we're trying to do events like symposia around some of these jurisdictions, but also just hope that it sparks debate within them, that the analytic tools we've come up with and the examples are useful in those jurisdictions.
Thank you, David. So before we go, could you tell us what's next for each of you, either individually or collectively? Ross?
Well, David's writing a memoir about his time in Guayaquil. No, he's not. I am working on my ongoing dissertation work on responsive judicial review, but we both have in mind future projects that build on this work, including a sort of design project, which is about how to build democratic resilience through design principles. And we've done a lot of the work, but we have to go back to that and do the kind of whack-a-mole plus extending and expanding that makes a book. And I think in the long run, we're also very interested in the economic underpinnings of liberal democracy and our work on social rights as a part of that challenge, right? Which is, I think, the next decade, especially after COVID, where so many people's jobs and livelihoods have been impacted and where we're going to have huge budget deficits, pressures for austerity, but real suffering. I think we are really interested in keeping democracy alive, as well as people's, livelihoods and dignity through a kind of pragmatic, realist, but generous approach to social rights. So that's another piece, but that's way off in the future. I think the immediate sort of priority jointly is to go back to the more optimistic view of law and constraint and say, what could law do there? And one of the things we're really interested in that context is think about resilience as a phrase that is increasingly kind of important to a bunch of fields. So thinking about psychological resilience, thinking about how buildings are designed. I mean, look at that Miami condo that's not that far from David, and just the kind of structural cracks that led it to collapse. You can think of democracy as having a kind of similar feature to it, right? So thinking about engineering and design and psychology as kind of useful frames, but also what we know already from the great work of the many people David mentioned and others about the kinds of design that can work. And we really want to pick up on our ideas about tiering and, the use of time and other dimensions of institutional design to think about a project about resilience.
Thank you, Ross. What about you, David?
Very excited about the resilience project, and I think the design piece of the project that Roz just mentioned. I think that'll be, that's going to be hopefully a significant book and kind of a companion to this book in some ways, but a different kind of project, one much more focused on constitutional design and hopefully a little bit more optimistic in some ways, I think, than this book. I mean, it's funny, I was talking about or presented this book that we just finished. It was a lot of fun to write or think about. And in some ways it was, but in a very dark way, right? Because you're just showing the different ways that this kind of abuse is carried out. Beyond that, I think Roz and I have some other joint work that we're doing, thinking about modes of constitutional change that we've worked on or are working on. A piece is, calling it restorative constitutionalism. We're kind of thinking about if you do have backsliding, then what, right? And we're thinking about the U.S. in that context, but also other, other countries around the world. What is the discourse of restoration as a constitutional discourse look like, and actually how can that be abused, right? Because we think there are examples of abuse of that restorative discourse as well. And then I guess, on my own kind of and as well as in conjunction with Ross, just a number of projects on using comparative law to think through problems of fragility or democratic backsliding in the US. And that, in some ways, it's a kind of bigger frame project. Some of that work has been done with Ross, some of it's been done with others, and some of it I'm doing individually. But there's so much to learn, and I think this is a period in which the US is a little bit more open to these comparative influences, hopefully, than it historically has been. And a lot of that learning, I think, very interestingly, is learning from or ought to be learning from the global South, and I think a lot of my own work is kind of about the constitutionalism, the global South, the innovations, and the value that those regimes have for developed democracies. And to me, this feels like a period in which the US needs to be doing a lot of that thinking. I'm not sure how much of it we will do, unfortunately, right? But I think it ought to be.
Thank you. Well, that sounds fascinating. I'm really looking forward to it, and I'm sure that our readership as well. Hopefully, we can have you, both of you, back here very soon. Thank you so much again to both for being here. Abusive Constitutional Borrowing, Legal Globalization, and the Subversion of Liberal Democracy is part of the Oxford Comparative Constitutionalism series published by Oxford University Press. You can find more information about the book at the Oxford University Press website. And if you recently published a book on constitutional law and would like to be featured in the blog, you can contact us at ilcl.blogeditor@gmail.com. And for regular updates on our posts, follow us on Twitter or subscribe to our mailing list. Thank you and goodbye.